Welcome to the Deep Dive, the show where we take your sources and really get into them, turning information into understanding. Today, we're embarking on something quite unique, I think. A deeply human deep dive. It's into a stack of documents that reveal one individual's, persistent fight for justice against what she sees as huge systemic failures.
Yeah, absolutely. We're looking at an appeal submitted to the Court of Justice of the European Union, the CJEU, and we also have their formal response. And like you said, this isn't just a dry legal battle.
Not at all.
It's a really detailed account of a mother's struggle to reunite with her son, Charlie Stark, after Swiss authorities removed him. And her argument is basically that the whole European legal framework failed her.
So our mission today is really to unpack all the layers of this case. It's challenging. We'll explore the specific legal arguments Raiza Stark, the appellant, makes against various EU treaties and articles.
Right.
Then we'll sort of zoom out, look at the bigger systemic issues she talks about in public and private institutions. And finally, she actually proposes a whole governance model to fix these problems.
She does. It's quite comprehensive.
It really is. It's a story that, it makes you think hard about how justice works, or sometimes doesn't, and how systems can actually serve people better. So let's dive in. Okay, so at the heart of this, it's Raiza Stark's personal appeal. She says right up front, her purpose isn't just about getting justice for her family. Her son, Charlie, officially Lila Stark, was removed by Swiss authorities.
Yes.
But she also wants to highlight what she sees as serious failures. Failures within the Swiss legal system, the European Court of Human Rights, the ECtHR, and the EU itself.
And she puts it very strongly. She claims the decision to remove her son was taken to, quote, avoid responsibility rather than serve justice.
What?
And she says the ECtHR failed to uphold justice. In her specific case, application number 2550524. So, yeah, it's not just a personal complaint. It's framed as a major challenge to these institutions. And that initial response we mentioned from the CJEU registry, it's dated June 17, 2025, and it really sets a firm boundary right away.
What did it say exactly?
They basically say, regretfully, they're not in a position to take any action concerning her email and the application it contains. They spell out that the CJEU's job is about EU law, interpreting the treaties.
Right, not national law.
Exactly. They don't interpret national law, and they're not an appeals court for national courts. Disputes with member states or, private individuals, that's for national courts.
Okay.
And they add that private individuals can only sue an EU institution, not a member state, at the general court. And crucially, you need a lawyer, mandatory legal representation.
So that initial response really throws up some big hurdles for her right from the start, jurisdictional hurdles.
Huge ones. Yeah.
But what's really striking, I think, is how Raiza emphasizes this isn't just about her personal suffering. She says it reflects a broader issue, a pattern of systemic failures affecting many families across the EU.
Mm-hmm. And she has that analogy.
Yes, the analogy, it's really vivid. She says, it is like waiting for a crucial package to arrive, one you urgently need, but the delivery company repeatedly delays it without explanation.
Right.
Now imagine that instead of a package, what is lost is something far more important. Your legal rights, your access to fair treatment, or even your own children.
It really hits home, doesn't it? It takes this complex legal stuff and just shows the human impact of what she calls a broken system.
Absolutely. It speaks volumes about her perseverance, framing her own struggle in such, universal terms. It's quite inspiring in its own way, that determination.
Okay.
So let's unpack the core legal arguments she makes. It's quite detailed. She goes article by article, identifying specific legal and human rights violations she believes happened.
She really did her homework.
Yeah, she's meticulously linking her personal experience back to fundamental EU law.
Precisely. And she argues that the way the law works now, it's more of an article violation identification approach, as she puts it. Meaning it's good at spotting specific violations, maybe, but it's not really set up as a comprehensive problem-solving mechanism. She uses the existing rules to point out these bigger systemic issues she thinks need a total rethink.
Okay, so where does she start?
Well, first, she goes after violations of fundamental rights, using the Charter of Fundamental Rights of the European Union, the CRF.
Right.
For instance, CRF Article 7, that's respect for private and family life. She says this was clearly violated by Charlie Stark's removal and the whole custody situation. She calls the interference excessive and disproportionate, arguing it didn't properly value family unity.
Okay, that seems like a core point for her case.
Definitely. And then there's CRF Article 47, the right to an effective remedy. She claims that because her case got dismissed by various bodies, including the ECtHR, she was essentially denied a timely and fair resolution. She says her efforts to challenge things were just, well, dismissed.
And this is where her arguments get really interesting, kind of innovative. She doesn't just stick to the usual human rights angles.
No, she does something quite creative. She frames the whole administration of justice system as an essential service for citizens.
Like healthcare or utilities.
Kind of, yeah, like something people consume. And under CRF Article 38 and TFEU Article 169, which deal with consumer protection, she argues that these systemic failures, like the Swiss authority, KESB, or social services, just dismissing her claims without real justification, that these failures violate her rights as a consumer of that justice service. She says justice, this essential service, has not been provided in accordance with the protection required.
That's a fascinating way to frame it. Citizens as consumers of justice.
It really is. It implies a right to a certain quality of service. And she also brings in CRF Article 41, the right to good administration. She points to being denied an ECtHR account that's the court's electronic system because she wasn't a lawyer. She says that she's obstructed her access to justice even more.
So it's clear she's connecting these abstract legal principles directly to practical barriers she faced. And she doesn't stop there. She goes on to challenge core EU values and objectives from the Treaty on European Union, the TEU.
Exactly. She looked at TE Article 2, the core values of the Union: human dignity, equality, justice. She argues these need to be more than just words on paper. They have to be actively upheld. And the CJEU should step in when they're not.
And Article 3.
TEU Article 3. The objectives of the Union, things like peace, equality, protecting fundamental rights. She says these need to move beyond aspiration. They need, quote, clear mechanisms for governance, monitoring, enforcement, and accountability. She wants concrete action, not just ideals. And then there's a really powerful critique she makes regarding TEU Article 5. This covers principles like conferral, subsidiarity, proportionality, basically rules about who has the power to do what. EU versus national level.
Yeah, those are fundamental principles.
They are. But Raiza argues they're actually being twisted into bureaucratic loopholes that justify inaction. She claims they get used to shift blame when national systems fail, instead of making sure someone, somewhere, actually takes effective action.
Wow, that's a major challenge. Saying foundational principles are being used to avoid justice, not deliver it?
It's a very strong critique, yes.
Yeah.
It suggests the system's checks and balances can actually become barriers.
So this critique continues when she looks at judicial cooperation and accountability using the other main treaty, the TFEU.
Yes, the Treaty on the Functioning of the European Union. And here she makes another really bold argument, maybe her boldest.
Which is?
She argues that the legal profession itself and the justice system as a whole operate like state monopolies.
State monopolies, like a state-run energy company.
In a sense, yes. She cites TFEU Articles 37, state monopolies, 102, market abuse, and 116, eliminating market distortions. Her point is that this structure leads to inefficiency, a lack of transparency, unfair conditions for the users of the system.
The consumers of justice again.
Exactly. She calls it a judicial monopoly and claims it's actually incompatible with the EU's internal market principles and violates users' rights. She even says the European Commission should step in to fix this market distortion. She does. Citing TFEU Articles 83, combating cross-border crime, and 84, crime prevention, she claims that the kind of procedural problems and disregard for rights she experienced could be indications of deeper corruption and organized crime within legal and institutional frameworks. That's a very grave accusation.
She really isn't holding back on the fundamental flaws she perceives, and she then explicitly calls on the CJEU to use its own powers, right?
Absolutely. She directly points to TFEU Articles 263, Judicial Review, 264, Annulment of Unjust Acts, and 265, Judicial Review for Inaction. She basically says, you, the CJEU, have the power to review these acts, to declare unjust decisions void like my son's removal, and to hold institutions accountable when they fail to act.
So she's putting the ball squarely in CJEU's court.
Yes. And she adds another layer with TFEU Articles 272, Contractual Arbitration, and 340, Liability of the European Union. She talks about an implicit social contract, citizens pay taxes, the state provides essential services, including justice, and she argues institutions have a duty to do what is right that goes beyond just ticking legal boxes. They must be held liable for the damage caused by their actions or their inaction, acknowledging the real-world consequences.
Which brings us neatly to the next part, where she moves from the legal articles to detailing the real-world impact, the impact of systemic challenges on individuals.
Exactly. From the user or consumer perspective, as she frames it.
She says the frustrations people feel often come from deep-rooted structural deficiencies in both public and private institutions. This is where the abstract law meets lived reality.
And she breaks it down really clearly into 4 phases of engagement. It's a framework that makes a lot of sense when you think about interacting with any large system, actually.
Okay, walk us through those phases.
So phase 1 is access, initial engagement, and application. The user problems here. Difficulty getting clear info, lack of transparency, confusing processes, slow responses. Sound familiar?
Oh, yeah.
And internally, she links this to things like communication silos, old-fashioned methods, staff not being trained well enough, maybe not enough staff.
Right, the internal causes. What's phase 2?
Phase 2. Service delivery, product use, and consumer experience. Problems for users, poor quality service, maybe it's not available everywhere, resources aren't spread fairly, overcrowding, no personalization.
And the internal reasons for that?
She points to inefficient resource allocation, no real accountability for poor service, bad coordination between departments, and again, those market monopolies she mentioned, like the judicial system.
Okay, phase 3.
Phase 3. Financial transparency, issue resolution, and feedback. User issues. No clarity on costs or fees, feeling like prices are unfair, complaints getting dismissed, maybe even fear of speaking up.
And the internal reflection.
Things like inefficient budgeting, no independent bodies to review complaints, courts being totally backlogged, and potential conflicts of interest within the system.
Makes sense. And the final phase?
Phase 4. Long-term policy, product evolution, and system improvement. What users see. Policies that are out of date, no way for ordinary people to participate in decisions, and a general resistance to modernizing.
And the internal institutional causes?
A lack of proactive thinking about reform, not using data to improve things, focusing only on the short term, and weak enforcement of any rules that do exist.
That 4-phase breakdown, it really paints a picture, doesn't it? It shows how internal problems directly create those user frustrations we all sometimes feel.
It really does. And she sums it up with this candid list of how the system fails us. She basically says institutions too often prioritize power over people,
leading to systems that are
complex, unresponsive, unfair, unequal access, failure to prevent abuse. And the result, she argues, is a loss of public trust. And worse, maybe a normalization of injustice, where it just becomes easier or cheaper to keep a broken system going than to fix it.
That's a pretty stark assessment, but one that probably resonates with quite a few people's experiences.
I think so.
So, okay, she's laid out the problems, the legal arguments, the human impact. But she doesn't just leave it there, right? She proposes solutions.
Exactly. This is where it moves beyond critique to a constructive vision. She proposes a high-level governance model. It sounds complex, but the idea is to integrate principles and values, best practices, problem-solving methods, and legal frameworks.
Into a self-reinforcing system.
And that's the phrase she uses, yeah. The goal is governance that's effective, adaptable, and really aligned with the mission and ethics of the organization, whether it's the EU, a national body, whatever.
And she contrasts this with existing EU principles.
Yes, she says principles like proportionality, conferral, subsidiarity, the ones she critiqued earlier, they provide structure, but they don't inherently drive solutions or guarantee that governance actually serves the people.
So what should drive it, according to her model?
Principles that actually push for action and measurable progress. She wants governance guided by values that lead somewhere positive. It's a call for leadership that's more focused on impact.
And she provides a list of these principles, the foundations for a people-centered European Union.
A long alphabetized list, yes. Really thoughtful.
Let's highlight just a few that really capture that people-centered idea. Imagine a system that aims to be accessible, usable by everyone. Accountable, takes responsibility for results. Adaptive, can change when needed.
Crucial.
Do no harm, actively tries not to cause harm. Empowerment, helps people control their own lives.
Yeah.
Fairness, impartial, considers context. Healing, tries to repair damage and rebuild trust. That's an interesting one.
Very. Not something you usually see in governance models.
Justice, not just legal fairness, but tackling systemic barriers. People-centered, puts people's needs first. Obvious, but needs saying.
Absolutely.
Transparency, open processes, open decisions. Trustworthy, builds confidence through ethical action.
That list really forms a kind of ethical blueprint, doesn't it? It's not just about following rules, but about embedding positive values into how things operate.
Exactly. It feels designed to build or rebuild public trust. And she connects these principles directly to her proposed governance approach.
Yes, they're the foundation of what she calls her integrated child protection model approach to governance, although the principles seem applicable much more broadly. She argues that if you embed these principles, you shift the EU or any system from being tied up in procedures to one that actively protects rights, builds trust, and actually delivers solutions that improve people's lives. It's a holistic vision. Each part supports the others, making it scalable, adaptable. It's all aimed at working for the good of the people.
It's quite an ambitious vision, rising from such a difficult personal situation. It definitely adds that inspirational element we talked about, the drive to not just fix her own situation, but the system itself.
Absolutely. It shows remarkable strength and foresight.
So wrapping this up, what is her ultimate call to action in this appeal? It's clearly more than a plea for justice, as she says.
It's a demand for immediate action and accountability. She specifically asks the CJEU to do several things.
Okay, like what?
First, ensure the immediate return of her son. That's the personal core. Second, review the legality of the ECtHR's dismissal of her case.
Challenging another major court.
Yes. Third, hold everyone accountable, the EU, member states, national authorities, courts, institutions involved. Fourth, implement urgent reforms to stop this happening again, saying no other family should suffer due to unjust and harmful interventions.
So systemic change.
Definitely. Fifth, dismantle those judicial monopolies she talked about. Sixth, provide full reparations for the harm caused emotional, psychological, financial.
There's a final, broader point.
Yes, arguably the most profound. She asks them to reevaluate and align our value system at every level, to create a culture where everyone constantly reflects on their actions, ensuring they align with do no harm and do good.
That's a call for a deep cultural shift within these institutions.
It really is. And she emphasizes this isn't about technicalities or legal loopholes. For her, it's about justice, fairness, and the moral obligation to correct wrongdoing. She insists institutions must not only be held liable, but must also acknowledge the real-world consequences of their inaction. It's a powerful argument for being proactive, for preventing future suffering, not just fixing past mistakes, building a legal system that truly serves people.
What an incredible deep dive this has been. We've really traced one person's, meticulous and determined challenge to these huge legal systems. She lays bare what she sees as fundamental failures in how institutions serve citizens.
Yeah, and we saw how she connects those failures directly to individual experiences, moving from dense legal articles to that very relatable user experience of navigating bureaucracy. It shows incredible resilience and clarity of thought, doesn't it?
It really does, especially considering the personal stakes involved.
And we also got into her proposed solution, that high-level governance model, built on principles like accountability, transparency, being people-centered. It leaves us with a big question, really. Well, in our complex world, with so much information flying around, how do we make sure that the powerful institutions designed to protect and serve us actually stay focused on the greater good? How do they adapt and evolve to meet the real human needs they're supposed to address?
That's a huge question, and this deep dive certainly gives us a lot to think about. The strength of one person fighting for her family, her vision for a fairer system, and that reminder that ultimately governance should be about serving the people. We hope this encourages you, the listener, to think about your own interactions with large systems and what principles like transparency, accountability, and people-centered might mean there. Thanks for joining us for this deep dive.